Yes, we are all complete. The floor is yours, Prorector.
Hereby, I open this academic ceremony in which Florian Gamper will defend the academic thesis, a theoretical analysis of consent and coercion in contract law. Mr. Gamper, may I invite you to present a summary of your study and the conclusions of your thesis.
Thank you very much, Pro-Rector. I first would like to thank everybody who is assembled here. I truly appreciate the time you've all taken to read my thesis and now to be here at my defense, and I'm not taking this for granted. In those 15 minutes allotted to me, I will give you a brief overview of my research, and I will follow quite the standard format. I will first tell you what motivated me to write this thesis. I will then run you through my arguments, and lastly, give you the conclusions, and also suggest how this may lead to further avenues for research. Now, what motivated me to write this thesis was a question that has been bothering me since my undergraduate years when I was reading economics. And that is a simple question: what distinguishes coercion from free consent? Or put it differently, what is coercion? And why is it commonly thought that coercion negates consent? In standard economics and common sense, I would say, consent plays an absolute crucial part. It is the one thing that legitimizes commercial transactions. And I would argue that is also the case in contract law. In contract law, consent is an absolute hallmark concept. Now, of course, we know in practice things are a little bit more difficult, as there are many statutes that override consent and restrict what people can agree to. And we may also query whether agreeing to online contract through the constitutional consent. Nevertheless, consent is, at least according to the orthodox view, the hallmark concept of a contract. Now, what is the issue? The issue is the following. Every contract or every transaction is induced by some kind of pressure. And normally those kind of pressures are legitimate and produce legitimate outcomes. Exchange for apple and oranges creates an illegitimate outcome. But we also know there are certain kinds of pressure that do not have that result. Maybe a little bit of a trite example is a line from a bad mafia movie: your line, your brain, or your signature on the contract that does not produce valid consent. At the same time, similar in rescue cases, if the price for the contract is not reasonable, it does not produce legitimate transactions. And contract law follows this. And I quoted one of my highly esteemed opponents in my thesis, who said, like, pretty much all modern legal systems have a version of the idea that duress, whatever it may be called, invalidates consent. But the question I wanted to ask is, what really differentiates coercion from free consent? And I think it is important to answer the question for theoretical reasons and practical reasons. Let's talk about theoretical reasons first. An easy answer might be to say, look, it is just public policy. The law decides a certain price is illegitimate. That's all there is to it. Why would you need to argue further? But the problem with this account is that it limits the ability of consent to confer legitimacy in a transaction. Because before we can even say that there was consent, we need to determine whether the transaction was legitimate. So to put it slightly poetically, it is legitimacy that determines consent and not concerned legitimacy. Now, that is obviously a problem for people who believe in freedom of contract or the free market. But I would argue that is also a problem for any kind of notion of contract law that has a notion of consent. And this argument against the idea that there is such a thing as freedom of contract. That is all just different forms of coercion. Some of them are deemed legitimate and some others are not, has long been made, most famously by Karl Marx. So there's a lot theoretically riding on the idea that we are able to distinguish free from coerced consent without making reference to legitimacy of the transaction. The practical implication is that, yes, a lot of times we have a strong intuition whether something is coerced or not. Somebody putting a gun at you, clearly coercion. But what about sweatshops? Here our intuitions clearly diverge. Some people are absolutely clear and adamant that working in a sweatshop does not constitute valid consent by the workers because the workers' alternative is starvation. At the same time, their opponents are equally adamant that the consent is valid and pointing out that it's not the sweatshop itself that is the problem, but the abject poverty in which some people live that makes even working in a sweatshop seem like a positive alternative. Plausible argument. But how do those people then account for rescue cases? So our intuition is not always a clear guidance here. So my motivation was really to answer the question once and for all. And very early it dawned on me while I was doing my research that before I could answer the question, what is coercion? I needed to answer the question, what is consent in the first place? Or rather, why does consent have normative consequences? And I always had the hunch that there's a misunderstanding going on in the literature on this point. The two most prevalent accounts of why consent is creates legitimacy is the one that says consent is basically akin to choice. If you consent to something, you choose that thing to happen, and therefore you cannot complain about it. That's why it has normative consequences. But I argue in my thesis that cannot possibly be the reason. First, consent needs to be communicated to be effective, but choice does not. Second, one can choose something, but yet not consent to it. Therefore, I say it cannot possibly be the consent and choice of normative consequences for the same reason. The alternative to this account, most prominently articulated by David Hume, he argued that, I beg your pardon, that consent is basically a nonsensical concept, yet a useful one. Shear Schriftrein in modern times argued it is conceivable to have a society without consent, but it would be so impoverished, it would just be unfeasible. So although consent has no normative relevance as such, we just need this consent. Now, notice, Hume never argued why consent is a nonsensical concept. So all one needs to show that Hume's argument is mistaken is to show that it is actually a meaningful concept. That does not mean that consent cannot also have those attributes that Hume says. But what I'm arguing is it's not the only option. So what I say consent is, it's neither choice nor what I call a formality. It is two or more persons performing the same action. Not the same action in the sense of that people play football together, so they'll perform the action of playing football. No, they literally perform the same action, although the physical manifestation of that might be different. Why does that carry normative consequences? I argue that this account has normative consequences in any normative system in which it is normatively significant who performed an action. Now, that is not the case in every normative system. For instance, in utilitarianism, it is not the case. But in other ones, it is. For instance, in virtue ethics, and more importantly, for my purpose of my thesis, in what I call the liberal order. According to the harm principle, I can do whatever I want within any action within my area of sovereignty as long as it don't harm anybody else. So in this system, it's absolutely crucial who performs an action. So what I argue is that consent is a factual concept that changes who performed an action. How does that help us with the notion of coercion? It helps us in the following way. To create what I call a joint action, it is necessary that the consent giver and the consent receiver both intend to follow each other's intentions and to intend to perform the action in question. And there are certain circumstances when this is not possible. In the classic case, the highwayman saying to the victim, your money or your life, the victim cannot possibly intend to make the choice between the two because the highwayman made that choice for the victim. And in those circumstances, consent, as a matter of fact, is impossible if consent is understood as creating a joint action. It has nothing to do with normativity. It's nothing to do with disapprove of the action. It's simply, as a matter of fact, not possible. Furthermore, I argue that in almost any circumstance, what I call contingency announcement, consent might actually be impossible. A contingency announcement is simply a situation where a person has no choice but to choose because of the intentions of another person. The problem with that is that most offers, as innocently as they may seem, like offering somebody a cup of tea for $10 or for $1, sorry, not $10, $1, would have the same form as a threat of the highwayman. So how is it possible that we can consent to buying a cup of tea for $1 but not to the highwayman? It is possible if the offer does not change the choice set of the victim. And I do apologize to my panel that I'm going through all these arguments a little bit quickly because they're quite detailed, and in 15 minutes it is unfortunately possible to go into all these details. From that, then I conclude that there is a difference about the factual difference between coerced and free consent, and that can also be applied to rescue cases because every price above the reserve price of the rescuer constitutes an intentional connecting two events, i.e. rescue and paying money. The only price that it does not is the reserve price. So that is the theoretical account that I give why coercion invalidates consent. I then further argue that in contract law, although nobody really had that notion before, we do follow this account. I first set out to prove that contracts are indeed best conceived, not as promises, but as any other sort of that has been postulated, but that they are joint actions. Some of the arguments I bring is that contracts are forms of communication. Contracts are interpreted. Contracts are not merely evidence of a person's intention. What matters in a contract is what has been communicated, which is in line with my theory. Furthermore, another argument I bring is that otherwise, one cannot possibly explain the doctrine of privity of contract. So then going through the cases, I say that especially the English common law fits very, very neatly with my account of contracts. German law also, but to a lesser extent. So overall, then I conclude that my theory of what a contract is, of what constitutes coercion is correct. Now, why is it then important? It is important for the following reasons. First, I argue, or I show in my thesis, that consent is a factual concept, not a normative one. I further show that it is not a spectrum, it is binary. Consent is either being given or not. There's no such thing as a little bit consent. I further show there's nothing as informed or free consent. Consent is either there or it is not, and at least in theory, it can be determined factually. That goes very much against the notion that consent needs to be understood as a spectrum, that the wider implication needs to be taken into account. According to my theory, that all might be relevant for choice, but not for consent. Where does this leave us with the more, so also that means that this whole idea of freedom of contract, whatever one may think about it on a normative front, they are not meaningless concepts. There is a factual difference. And where I hope to take this research further is to apply it to competition law. Competition law a lot of times struggles with the normativity of how to divide things equally or fairly. And then that just appeals to common sense notion of fairness, which then is very heavily criticized for that. But I hope through my research in the following steps to further develop it into an alternative to the Pareto and Calder-Hicks standards, which then gives a more meaningful account in competition law what constitutes a fair division of profits. So as I understand, I've been given 15 minutes and I tried my best to stick to this timeline, but I appreciate that I glanced over a lot of details, but I hope that my highly esteemed and esteemed opponents will maybe raise some of the more detailed points in their opposition arguments.
Thank you very much for your presentation. The opposition will now be opened by Professor Jaap Hage. Professor Hage is an emeritus professor of jurisprudence at this university, and Professor Hage was also the chair of the assessment committee. You have the floor.
Thank you very much. Dear candidates, first, let me congratulate you with writing this PhD thesis. Your work illustrates how philosophical issues can be relevant for practical legal questions and shows the relevance of philosophy for law. Your thesis therefore deserves a philosophical question. And already the very first sentence of your introduction has raised such a question. In that sentence you write, and I quote with a little paraphrase, "The objective of this thesis is to show that there are factual reasons, it has non-normative reasons, why coercion vitiates consent to a contract." Personally, I have wrestled with this question of what is factual and whether it's opposed to normative since I wrote my own PhD thesis somewhere in the 1980s. Why would people distinguish between what is factual and what is normative? My hunch is that they think that facts are objective and that what is normative is not objective. However, that immediately raises the question of what objective means. The common answer to that question is that what is objective is independent of human minds. So to speak, it's out there, and how we see it doesn't matter. But then there are many facts which are not objective. Take, for instance, sounds. Does a falling tree in a deserted forest make a sound? It obviously does not. The falling tree causes vibrations in the air of the forest, but only if these vibrations are caught by an ear and processed by a brain do they represent a sound. The sound is mind-dependent. Something similar holds for colors. Only when processed by an eye and a mind do electromagnetic waves represent the color. The same holds for everything perceived by our senses. It seems, therefore, that there are few things that are objective. If facts, in contrast to what is normative, are to be objective, the sad conclusion must be that there are only few facts, if there are facts at all. But suppose that facts do not have to be objective. Then the opposition between what is factual and what is normative seems to collapse. And I think therewith the basis for your thesis. And the sad conclusion must be that there are only few, normativity is not objective, but neither are facts. And that brings me to the real questions. The distinction between what is factual and what is normative plays a central role in your thesis. And therefore it is desirable that you have satisfactory answers to the following two related questions. First, what do you mean by factual? And is there, in your opinion, a relation, if only negative, between what is factual and what is normative? And two, why do you define factual as non-normative? There are many things, including sounds and colors, but many more other things. I also think actions, for instance, that are as mind-dependent as normativity. Why not oppose them to factual as well? I look forward to your answers.
Thank you very much, my highly esteemed opponent. And I would like just to say that I was very much looking forward to your question, because I am familiar with your work and I'm a great admirer of your work. And in my humble opinion, actually, I think our positions are not as far apart as it may seem at the beginning. So why do I say it is factual or not normative? The reason is that there are many theories about what consent is that says, look, in the end of the day, all one can do is to look at a situation and then assess normatively whether the situation is legitimate or not. So you take into account all the facts, and I'm going to say label what those facts are, and then you assess the normativity of it. Now, actually, I agree with that. But my point is, it cannot possibly be that consent is only this normative assessment of a situation, because before we can actually assess a situation normatively, we must know what the situation is. And especially I refer to Alan Wertheimer, who makes this point about consent is purely normative. It's just, he sort of says, look, we can think of consent as this really thin concept, just saying the words, I consent, but this doesn't really tell you anything. To assess the situation, we must know everything about it. I agree with the premise, but not with with Wertheimer's conclusion. I agree we have to know the facts. So we now need to know who did what happened, if a person died or whatever, and only then can we assess the normativity of the situation. I would even go for, 2 points in support of this conclusion. As a matter, after just looking around at normative systems, they always try to ascribe certain normative meaning to facts. Utilitarianism says, look, happiness equals good. I'm being very broad here. Virtue ethics says, like, a virtuous act equals good. Liberal says, look, if it's an act done by yourself, you can do whatever I want. So and I would say all the normative theories that I'm familiar with look at the facts and then connect them to normative evaluation. My point was that consent belongs to the descriptive, to the factual thing, which then gets evaluated normatively, not the other way around. And regarding why I define facts as versus non-normative. Now, I didn't really define it. I'm just saying as opposed to non-normative. The reason why I did that, because I didn't want to commit myself exactly to the whole debate, what are facts or not. All I want to say is, like, it is not normative. And by normative, I mean things that evaluate, something that tell us what we ought to do rather than what is the fact. So all I'm saying is that it does not belong to the normative realm. It belongs to the factual realm. Now, what exactly we mean by factual? There are many propositions out there, and I would say my idea of what factual is probably compatible with most of them, but my main point was just to differentiate it from the normative side. So saying, look, it doesn't belong to the normative sphere, it belongs to the factual sphere. Regarding the mind and mind independence of, I partially agree with the assessment that, when we say factual, we mean objective. True, but that's not necessarily why I'm saying it has to, why I think it's desirable to have this objective. It is desirable because otherwise the notions like freedom of contract, free market, and so on become meaningless. And I was trying to show that they are not. Has objectivity to do something with mind independent? Yes, but I would argue it slightly differently. There's clearly, potentially, objective fact about the mind, which are purely factual. So if the subject matter is a mind, there's no reason why that cannot be assessed factually. For instance, how a person perceives sound or colors, we can make an objective statement and saying dogs do not have the receptors to perceive color, and they can only see black and white. It has to do something with the minds of the dog, but I don't see that there's a stark difference between making that statement and saying dogs have 4 legs. Saying, look, they don't have the receptors, and I think factually that's true. Forgive me if it's not true that the colors, but I would say like dogs cannot see colors, right? So this is a factual statement about the minds of the dogs. Same way we can say that about a human being. So it's not so much that the objectivity is the mind dependency, because I think that can be assessed factually. For me, the important point was it is not a value judgment to say whether there is consent or not. It can be accommodated within the realms of what many, within the factual, whatever theory of factual you conscribe. I did make the concession that it's all dependent on the idea that you think of the idea of of intentional action as a factual concept rather than a normative concept. So if you think the whole basis of what constitutes an intentional action is in itself a normative concept, then yes, fine. The whole thing also then becomes normative. But as long as you make the assumption that the concept of an intentional action is a factual rather than a normative concept, I argue it follows that consent is also a factual concept. And there are some people out there who say nothing in a way is factual because it's always dependent on our motivation to find out something. I disagree with that notion, but I think I didn't want to get drawn too much into that debate, and I think it is a very important one, which I'm very keen on. But I would just say, like, if I would have spent an entire book defeating that idea, they're saying that there are no facts out there, it would have been a very, very different PhD. So I accept a very, very fair notion of factuality, which is just to say it is not normative.
Thank you, Mr. Candidate.
Sorry.
Thank you.
Very
I think
much.
Professor Hages has been satisfied. The opposition will now be continued by Professor Peter Czerne. Professor Czerne is a professor of law at the University of Aberdeen and was a member of the assessment committee, and we welcome you very much online here in Maastricht. Please go ahead.
Thank you very much. Dear candidate, I was very glad to read this serious and ambitious and challenging thesis, not the least because I wrote about freedom of contract myself more than 15 years ago, and I realized so much new can be said about this topic. My question is simply whether you could make this key conceptual move, analyzing concept in terms of joint action, a bit clearer. So at the beginning, you state cases where individuals create joint actions closely correspond to cases where individuals give consent, which suggests consent creates joint actions. And page 311, consent means that multiple individuals perform an action together. And there are many examples in the general chapter 4, but I was not entirely sure what joint action there means. That's the first part of the question. So if we focus on one example, page 141, you correctly say, I think, that if the patient doesn't give consent to an operation, the surgeon performing the operation would commit battery. But then what does it mean to analyze such consent in terms of joint action and say that the patient did the operation on themselves if they give the doctor consent? In the other example, the action of the officer saying the words, "You may switch on the light," can be described as the same action as the action performed by the soldier when he switches on the light. So initially, this use of the word is a bit implausible. Now, you could say this all what it means for both X and Y to act when X gives permission to Y and Y then performs the action is that person X intends person Y to act in accordance with both X and Y's intentions. If this is all what it means, then it indeed makes sense in some scenarios. But I think it's still an odd choice of words. So I would appreciate some illumination on how, whether through these or other examples, how the relevant actions are described as joint action rather than giving permission or making an agreement. However, with regard to the patient example, I think there is some further complication because on page 274, you say, and I quote, "A person deciding to follow another person's advice on whether to give consent to this person makes consent impossible." So does that mean that the patient cannot give consent at all to the doctor to operate on them? Thank you.
Thank you very much, my highly esteemed opponent. And he made it realize he actually played a very important part in my writing this PhD, because I read his PhD originally thinking making a juxtaposition between freedom of contract in contract law and or paternalism in contract law and economics. But then I actually found out that my highly esteemed opponent had already written it, and I read it. I was like, well, I can't really add much to that because I really, really admire it. So I needed to come up with a slightly different topic. Okay, now to the questions. Okay, so what is the difference between giving permission and my theory? So giving permission, I would say, falls into what I call a formality. Now, we can say that, as I said, like consent can be understood as a choice, but for the only reason, again, it cannot possibly be that choice has this, or the consent has the normative consequences for the same reason as choice does. So the alternative is then to say, look, we just create a system where certain words or actions have certain normative consequences, not because they change anything substantial or factual. It is simply because we deem them to have those consequences. And I call it a formality. For instance, like signing a contract, you could say, well, it doesn't really change the facts, but legally it makes a huge difference. So that's what, for instance, Hume or Schifrin say what consent really is. And I think your idea of just giving permission falls into this category, saying, look, you don't, the question, why does permission have normative consequences? And they're saying, well, it is just because we as society have decided that it shall have these consequences. Now, some of the problems with this notion is that, first of all, saying like, it is the implied assumption that consent really does not change anything factually. But I was trying to show that there is a factual difference, and that is who performed that action. Now, why does it matter? If, let's say, consent is just a formality given permission, we can ask a lot of questions about consent. We can say, look, why do we have this formality? Wouldn't it be better if we phrase it slightly differently and say, oh, it would be better if only informed consent carries the normative consequences, or a certain amount of freedom need to be involved. And I think that is perfectly possible. You can do it as a normative system or as a legislative system. You can absolutely do that. But if in your normative system, it matters who performed an action, then this is ipso facto a question that needs to be answered. And consent contributes to answering the question independently of permission or anything else. So the reason why I say when I give consent to the surgeon to perform on me, it has the same status, not same status in terms of like attribute. It is as a factual matter. It is as I perform the surgery on myself, that is why care has normative consequences. So you might say, look, I don't care about who performed an action, and that is obviously your prerogative. But in the liberal order, as it is now, we do care. And I'm saying those facts then need to be taken into account. The same way we ask who performed the action of killing somebody, as a matter of fact, we need to address that question. Then we can apply normative consequences to the person who killed. You might say, look, I don't really care who kills anybody. All I care is about happiness. Fine, obviously your prerogative. But if you get the position saying, look, it matters who performed an action, then you need to answer who performed the action, and consent contributes to this one. So the same, and it's not just a choice of words, or at least so I argue, that when the officer gives consent to the lights being switched on, then as a factual matter, assuming that the concept of intentional action is a factual concept, they both perform that action. So that means the cat. Sorry.
Thank you, Mr. Candidate. I think Professor Czerne is happy with the way in which you have responded to the question. Then the opposition will be continued by Professor Sonja Kruisinga. Professor Kruisinga is a professor of contract law at the Open University and was also a member of the assessment committee. You have the floor.
Thank you very much, Mr. Rector. Mr. Candidate, let me first compliment you as to the topic that you have chosen for your PhD thesis. I've read your thesis with interest. The topics of consent and coercion are at the heart of contract law, as they deal with freedom of contract and party autonomy. Can there be consent in case of coercion? Which are the consequences of coercion for the enforceability of contractual obligations? Which limits does the law set to party autonomy, and what is the role and function of contract law in this respect? The objective of your thesis is to show that there are factual reasons why coercion vitiates consent to a contract, and that as far as consent to a contract is concerned, there is a factual difference between free and coerced consent. If you allow me, I would like to turn to page 211 of your thesis, where you elaborate on the possible distinction between a threat which is credible and a threat which is not credible. And you state, consider the case of a builder who threatens not to complete a building project if the contract price is not increased, which I have to say is, very relevant in today's economy. I continue your quote. It may be the case that the builder's costs have increased and that without the price increase, the builder would not be able to complete the project, or the builder was offered a more lucrative project. In this case, the threat, as you say, or rather the warning, not to build the project is credible, because if the contract price is not increased, this will result in the builder not finishing the project. If the innocent party agrees to the higher price, the innocent party will benefit from a rule which states that this amendment will be enforced. And then you continue stating a little further, by contrast, the builder may ask for more money even though they could finish the project without increasing the contract price. In this case, the threat is not credible, because if the innocent party does not increase the contract price, the builder has an incentive to finish the building project. If the builder does not finish the project, they will be liable for breach of contract, which usually means that the guilty party has to put the innocent party into the position as if the contract had been completed. But if the builder finishes the project, the builder will receive the contract price. End quote. I would like to raise two questions in this respect. First of all, does this example really deal with the threat that you discuss in your thesis? As in this example, there is a contract, and the threat seems to relate to the performance of the contract instead of the conclusion of the contract. And secondly, my second question, would such a case truly be a case of threat, as there are also other contractual mechanisms that can be used to solve such a case? In this context, I can imagine that either party may suspend the performance of its contractual obligations, which may be permissible, and this would mean that applying rules on threat or coercion may not be necessary in order to solve this type of case. I look forward to hearing your response.
Thank you very much, my highly esteemed opponent. To the first question, whether it relates to contract performance or the creation of a contract, the way I thought about it is that if the contract is amended, that can be conceived as a new contract coming into force. So that's what I would say to that. Regarding other contractual mechanisms, absolutely, there are many other contractual mechanisms that are in place. When as a practicing lawyer, I used to draft a lot of construction contracts, which sometimes got to like 10,000 pages. Now, most of it was just technical drawings, and it was all about you had to get certain milestones and certain monies would be released and so forth. It was very complex. And I think that this emphasizes the nature of the problem, that if you are if you are sort of in bed with a contractor, it is very difficult once the project has started to walk away. So the contractor has a lot of bargaining power because of the party that hired them. They will find it very difficult halfway through the contract to the project to switch the contractor, and they are very well aware. And yes, through contractual means it can be redeemed to some extent, but it's unlikely to be absolutely perfect. Now, one way of doing it is to stagger performance, to having milestones, and that takes out a lot of the pressure. But in the meantime, let's say between the staggering performances, you still have the same problem. You can reduce it, but you can never really make it go away. And contract law has been wrestling with this question for a long time. So the original position, at least on the English law, was that no, you cannot increase the price, even if without an increase in price, the contractor could not finish the job. Now, that was obviously highly undesirable for both sides, because once I said, look, I want to finish this job, and if the other party genuinely cannot do that, I want to help them out. But it was not possible. But then the case law has changed and then recognized it and said, like, okay, there's new consideration following, because you get the other side gets a practical benefit by renegotiating that contract. And my point here was simply that this very much corresponds to what my idea of when contracts should be enforced. In this case, if it's a price increase, completely innocent, unforeseeable, the other side wants to pay that price to get the project over the line. The law, as it currently stands, enforces these contracts. And I'm saying, like, according to my theory, those contracts would also be enforced, because it was not the intention of the guilty party to break the contract. It was simply, as a matter of fact, they could not perform that. So I was just trying to emphasize that the correspondence between the law as a practice and my theoretical account of coercion as it is now.
Thank you very much. I see that Professor Kruisinga is satisfied with the answer. So the opposition will now be continued by Professor Caroline Kaufmann. Professor Kaufmann is an associate professor of private law at this university and was also a member of the assessment committee. You have the floor.
Thank you, Mr. Pro-Rector. Dear candidate, dear Florian, if I may. First of all, allow me to congratulate you on the completion of your thesis. The task you took upon you was a courageous one, to defend the traditional but highly criticized view of consent as the basis of contract law. And you accomplished that task with great confidence and great eloquence. Nevertheless, I would like to challenge you on one of the strategic decisions you have taken when setting out your research. In part one of your thesis, you rightly raised the question of whether the rise of the digital economy impacts the importance of consent in contract law. That's on page 30. On page 33 and the following, you further investigate the question. Your starting point is that in the digital economy, contracts are concluded without there being a realistic opportunity to read or negotiate the terms. You then point out that opinions vary on whether this requires a new view on contract law. Some scholars argue that the way of contracting in the digital economy does not necessarily mean that there was no consent, and others argue that the issues raised by the digital economy are better addressed through regulation than through changes of contract law. After that, you turn to another element that is characteristic of the digital economy, big data, that allows for predicting consumer behavior and targeting people when they are likely, and some will even say vulnerable, to being convinced or manipulated into buying goods and services. After that, you raise the question as to whether contract law de lege lata can and de lege ferenda should take into account such practices as manipulation. You also point out the possibility of perfect price discrimination, allowing sellers to absorb all the consumer surplus. I found one further paragraph dealing with the digital economy on page 37. Even if the challenges from behavioral economics and the digital economy could be answered, it still does not follow that consent should be set aside only in special circumstances. Consent alone does not guarantee that the transaction is legitimate because other values like substantive justice are also important. I fully agree. But as mentioned, we are only on page 37 of your thesis. And you made me very curious as to how your theory will deal with and offer a solution to the challenges raised by the digital economy. But then I didn't meet the concept digital economy or even digital anymore until I got to your list of literature. I found a reference to clicking as a form of accepting an offer, but apart from that, nothing about the digital economy until the list of literature and the impact paragraph. And there, in the impact paragraph, you mentioned that you expect that your theory will be relevant for the digital economy and more in particular to answer challenges of smart contracts. But in the body of your thesis, you illustrate your points using cases about bottles of water in the desert, torture, and soldiers following orders, instead of the daily challenges of consumers in the digital economy. Why? And what does your theory mean practically for consumer contracts in the digital economy? I look forward to your answer.
Mr. Candidate, may I ask
yes.
you to provide a brief answer, please?
Yes, okay. Thank you very much, my esteemed opponent. I'm very, very glad that about your question. So what does my theory say about digital contracts? Now, my theory denies that there's any additional requirements for consent, informative and what else, which makes it sound that I'm very hardcore on consent. However, the implications are as follows. First of all, when it comes to price discrimination, as it says, like with perfect price discrimination, one party can potentially appropriate all of the consumer surplus. And there's exactly the kind of scenario where I say it is not possible actually in those scenarios to give consent. So in that case, it is very, very highly relevant. And I try to formulate this more formally for competition law to say, look, competition law really, really struggles with these cases because in a way, they're not inefficient. There's no decrease of consumer and producer surplus. It's just one gets more than the other. And competition law so far just usually applies like common sense and saying, look, this is just too much. You cannot do that. But it is very unsatisfactory to have this sort of common sense approach about, well, it's just unfair how do we distribute that. And what I'm hoping to do is to show that it's actually, as a matter of fact, impossible to consent to these sort of contracts, to really give clear guidance and say like how consumer surplus ought to be distributed to avoid the scenarios that only one party receives all of that. The second point which I wanted to make is that because I have this strong difference between choice and consent, this allows me to say, look, the consent was there, but the choice, which is also there, that is the critical aspect. So let's not focus too much about the consent aspect of it, but let's focus about the aspect of people making choices. And I think that is a much better way forward, because it is the choices that matter. If you spend, hours and hours on TikTok and teenagers being told, about how to commit suicide. Sorry, I'm exaggerating maybe a little bit. It is the choice that matters. It's not about the consent. The consent is just not there. There's no contract. And I'm just saying, like, we should much more focus on the choice aspects, which may be done by a third party, rather than by the contractual party, rather than on the pure consent aspect. And ultimately, you have the difference between choice and consent. I think it gives you the possibility to do in a much more fruitful way to analyze those cases, to say, look, there was consent, but the choice nevertheless was undesirable, and we need regulation for that. Sorry for being brief.
Thank you very much for that, Mr. Candidate, because that provides us the opportunity to continue the opposition by Professor Danielle On. Professor On is an assistant professor of private law at this university. You have the floor.
Thank you, Mr. Prorector. Dear candidate, first and foremost, I would like to echo the thoughts and praise already voiced by the other members of the Corona. You have written a highly original thesis on the contract law doctrines of duress, undue influence, and unconscionable bargains. And you make an interesting argument that they do not rely on the notion that the contract was induced by illegitimate pressure. In doing so, you have informed, enriched, and stimulated my own thoughts on the justificatory role of consent in contract law. However, you have set up in the first part of your thesis a very bold argument on which the rest of your thesis is built. The thesis sets up from the very beginning the ambition of formulating a purely factual or empirical account of consent, and dismisses, perhaps too easily, the idea that a sensible interpretive theory of consent requires a wider normative system. You do this on pages 70 and 71 specifically. I have to say, I remain unconvinced that a purely factual account can do the interpretive work you require it to do. To make this more tangible, I'd like to go to an interpretive problem that has to do with the way consent is formed in the first place and not to its free character. Suppose two commercial parties from two distinct jurisdictions, you'll be familiar with them, jurisdiction A and jurisdiction B, and have the following exchange. The first party, the offeror, dispatches a letter containing the offer, which is duly received by the second party, who also accepts the offer by letter, to be delivered by traditional post. Immediately after the letter is dispatched, but before it is received, the offeror calls by telephone and retracts his offer. Suppose it is not yet clear which law applies to this contract, and the law from jurisdiction A has a well-established rule that acceptance becomes effective upon receipt, just like in many civil law jurisdictions. Whereas in jurisdiction B, it is well established that acceptance becomes effective upon dispatch, the postal or mailbox rule. If the rules from jurisdiction A apply, legally speaking, there is no consent. If the rules from jurisdiction B apply, then there is, because the retraction is not effective. In this example, the only thing at stake in determining whether consent exists seems to be the applicable rule and not the empirical facts. In your thesis, you stress the fact that normative frameworks may be relevant in determining the normative consequences or effects of consent, but not consent itself. However, I am curious how the theory of joint action you developed in your thesis makes sense of scenarios like the one I've just presented. Is there perhaps room for pluralism within the theory of joint action? Or is one of the theories, receipt or dispatch, simply wrong from an analytical point of view? Or have I misread your distinction between factual and normative. And this gives you a chance to get back to one of the questions.
Thank you very much, esteemed opponent. And no, you have absolutely not misunderstood. And actually, you highlighted a very, very important point, which I sort of glossed over in my 50 minutes introduction. I'm saying consent is a factual concept, but it does not necessarily mean that other concepts that we cannot have, additional concept with that, i.e. what you call pluralism. So what I'm saying at the very heart of contract law is the question who performed an action. But as contract law has evolved, many other aspects have been contributed to it. Disputes in labor law are usually governed by statute, and it's not so much a contract for employment is governed by all sorts of other principles. And I have no problem with those principles. All I'm saying is it is possible, as a matter of fact, to say there is consent, and that is what a lot of contract law follows. That does not mean that sometimes when it comes to, and I mentioned the postal rule in my book as well, sometimes we have to decide for business efficacy. That's why the postal rule was created in the common law, that, we diverge from those sort of things. And we can see that in many other forms, like, for instance, like in under English common law, contracts for the sale of land have to be evidenced in writing. Now, my theory says nothing about writing versus non-writing, but I can see why it is a useful thing to have contracts for land, because land is usually quite a valuable property, to have that in writing. The same way, we can have many, many additional criteria. What I'm arguing against is saying that it's normatively all the way down, which many scholars now seem to say, that, okay, the whole concept about consent is just, you cannot approach consent or coercion without, it applying, some normative concept to it. And I'm saying that is wrong. We can do that. But it does not mean that I'm saying, that they somehow follow that we are not allowed to have additional criteria. And sometimes additional criteria, as you correctly point out, are there and are useful. So, yeah, so I'm just saying, like, it can't, it is factual, but it does not mean that we cannot have, the law can do whatever it wants, basically, add additional normative criteria to the scenario. So I guess to some extent, yeah, there can be pluralism, but that does not change that consent in itself is a factual concept. We can also introduce other forms of, saying, look, there was consent, and we just can call it consent because the law can do whatever it wants, and I have no problem with that as such, if that answers your question.
Dear Prorector, could I
Go ahead.
Could I push back on this a little bit?
Yep.
The three theory you present in that second and third chapter are either that consent is a purely factual concept, it's a purely normative concept, or it's a factual concept that requires also a normative framework. And I would agree with you that it's not a purely normative concept. This part of the answer is definitely convincing. But I was trying to get to how we can reject the idea that it's a factual concept that also requires these additional components which are normative. So then it's a factual component within the frame of a normative system. So I would like to ask how you would respond to that.
I 100% agree, and that's what I'm saying throughout my thesis. It's like, it's a factual concept that within certain normative structures have normative consequences. For instance, and the one that I discussed is the liberal order. It matters in the liberal order who performed an action. So if I grab this pen, I'm allowed to do it because it's my pen. If somebody else does it, they either commit a wrong or need to justify it. Now, the facts themselves obviously do not lead to any sort of normative situation. I'm not, in that regard, I agree with Hume. You cannot derive an ought from an is. So I'm just saying, but what is changing when it comes to consent is the facts. And what a lot of people say, no, there is no change in facts when we give consent. And my whole point was, now there is. Obviously, the normative consequences of the change in the facts are dependent on the normative system. For instance, like in a utilitarianism, you might say consent plays no part because all we care about if the action has positive consequences, and say indirectly maybe, as but not, we don't really care. And I think that also fits together, saying like, look, even without consent, it might be positive consequences, but in other normative system, it matters. And I think in a liberal system, as we have now, it does matter. And in contract law, it does matter as well. A lot of contract law corresponds very, very closely to that. But as I said, there's nothing in my theory that says, in addition, you cannot do all sorts of other things. And I don't think that changes what I'm trying to say, that consent is a factual concept. And then, as also said in my thesis, there are cases.
Mr. Candidate, you may briefly conclude your answer. Briefly.
Okay, as I'm saying, that there might be cases, and then discuss them in my PhD, that we use the word consent and then no joint action is created, but we treat them as such. And I would say when it comes to the postal rule, this is exactly what we're doing. And I have no problem with that, but it does not change the main thesis that consent is a factual concept.
Florian Gamper, the time appointed for defending your thesis has now passed. The degree committee will now withdraw to discuss the quality of your thesis and your defense. I request that you and your company await the results of our deliberations and our return. We will now go to a breakout room. Mr. Florian Gamper. The degree committee, here present online, has assessed the quality of your thesis and of your defense. In view of its positive verdict and taking into account your previous qualifications, the degree committee has decided to grant you the degree of doctor. Professor Smits, your supervisor, is authorized to confer upon you this academic distinction in accordance with Dutch university custom. I invite your supervisor to now take the floor.
Dear candidate, dear Florian, do you promise to work in accordance with the principles of scientific integrity at all times, which means to be careful and honest, transparent, independent, and responsible?
I promise.
Then, by the authority vested in us by law and in conformity with the decision of the committee here present online, I hereby confer upon you, Florian Gamper, the degree of doctor and grant you all rights attached by custom and law. And as evidence of this, you will soon receive the degree certificate signed by the rector, the secretary, and the supervisor, and affixed with the great seal of the university. And that certificate will now be shown by our beadle. Now, esteemed Dr. Gamper, dear Florian, it's a true pleasure to be the first person to officially congratulate you on the doctor's degree that you have just acquired. And that took place in a special academic ceremony. Special, first of all, because your defense took place entirely online. And we all would have loved to have you here with us to hand you the diploma. But I know this was not possible with you being in faraway Singapore. Second, also special because of the thesis that you defended here this afternoon. It is a real thesis, defending a firm view, namely your view of consent as being a factual phenomenon, and arguing very much in your book why you believe others are wrong and you are right. As such an ambitious exercise, of course, invokes its own criticism. So today you were the one who had to defend your view against the arguments of your esteemed and highly esteemed opponents. And you did so at a very high level with a lot of conviction and rigor. And that's also the way in which I have come to know you in the last 6 years. Now, how did this all start, Dr. Gamper? Well, it started, in fact, with an email dated the 10th of October 2019. And the first sentence of that email read, "Dear Professor Smits, I hope you don't mind my getting in touch." And you inquired whether I would be willing to accept you as a PhD researcher. And of course, I was very much willing to accept you. And you came to Maastricht with an impressive background, both academically and as a practitioner. You had then a bachelor's degree and a master's degree in philosophy and economics at the London School of Economics, and a master's in law at London University Queen Mary. And you had worked as a corporate solicitor and consultant in London before moving to Singapore in 2015, where you also worked as an academic researcher at NSU. What was very important to me was that you told me that you wanted to make academia your full-time career. And that was also a reason why you wanted to do a PhD. So in December 2019, you started working on the thesis with Monica Lesinska as a second supervisor. I'd like to mention Monica here because she played an important role in the first few years of your trajectory before she moved to the Texas A&M Law School in Dallas. You wrote on the ambitious topic of consent in contracts. And that's ambitious because so many people wrote about this before. And then it's difficult to come up with your own new and original views. But here, in fact, I like to quote Patrick Attia. Patrick Attia, the famous late English contract lawyer. And when back in the 1970s, he told colleagues he was writing on consent, these colleagues told him that it seemed to them, to these colleagues, that the path had already been traveled by many others before. The answer that Patrick Attia gave there was, yes, but not by me. And I must say, I felt a bit of the same attitude in how you approached the topic, trying to add new insights and arguing for what you believe in. Now, was this easy? I don't think it was always easy. You encountered some problems in the last 5 years. The COVID period happened shortly after you started, where you told your supervisors that it was, and I quote, the routine that kept you grounded there. There were also some methodological problems that you faced. Sometimes it was difficult to convince your supervisors of your views. And has even led to various versions of what you called a faux introduction. I like the term very much. But you did great and you managed, and today you very much deserve the doctorate, which is indeed for you not the start of an academic career, because your career had already started, but it's a stimulus, I hope, for that career in the years to come. You are a researcher at Singapore Management University. You published widely on a variety of topics, including smart contracts, including federated learning, and law and AI, and now this wonderful thesis where you combine philosophy, legal theory, and contract law. And I very much hope that you will also publish the thesis with a good publisher, so that also the entire world of contract lawyers can get to know your views on this. So I congratulate you wholeheartedly, and in these congratulations I also involve your wife and children and all your family and friends. In an online ceremony like this, you miss out on some of the traditions of the ceremony, but there's one tradition that you will surely abide by, I hope, and that is to celebrate today and enjoy this well-deserved achievement. And I applaud you, Florian. Congratulations.
Thank you very much. Thank you. Thank you.
Dr. Gamper, also on behalf of Maastricht University, it is my pleasure to congratulate you with the degree you have acquired. We have a dean in our law school, well known to you, that when he is pro-rector, he always reminds us of the fact that this is the highest degree that you can obtain at a university. So I would like to stress that as well. And I have enjoyed very much all your references to law and economics in your thesis and during your defense. I will in a minute formally close this ceremony, but I would like to ask you not to disappear, as we then informally can congratulate you as well. Having said that, I now formally declare this ceremony ended.
Yeah.
Congratulations, Florian. Well done.